All right, good evening, everybody. My name is Kate Meadow. I am not Jennifer Burns, as it shows down in my little Brady Bunch square box over here. We use one account at work, and Jennifer is the boss of the Business Insight Center, so the account is under her name. I like to keep this kind of laid back and casual, so if you guys have any questions as I'm going on, please feel free to throw them into the chat. I do have someone monitoring that. That would be our wonderful coworker, Sarah. She's going to monitor the chat. So again, if you guys have any questions, put them in there. No problem. I'll try to answer them as we go. So Sarah, feel free to interrupt me. I do ask that you mute yourselves. You guys are already done, so thank you. You're making it easy. So the slides and this recording will be sent out to you. You'll get that in the next couple of days through your email. My name is Kate, as I mentioned, and I am the manager of the Carlson Center for Intellectual Property. The Carlson Center is housed on the 4th floor of the Central Library in the newer Bausch & Lomb Library building. It's part of the Business Insight Center, and the Business Insight Center is a relatively new concept for the library in that we take appointments basically as the majority of our clientele. We do accept walk-ins if we're not helping somebody, but because our research questions are so in-depth, we try to just take appointments so that we can spend the time that you need with us and not feel rushed. So we can provide small businesses of any size, whether you're a startup or you're 6 years into your company and you're growing, we can provide you the resources and the research that you need to actually help you stay successful. So Jen, Melissa, and Sarah, as I mentioned, they basically do the business aspect. So market research, industry reports, industry surveys, projections, how concentrated is a market for a particular technology, or, if you want to open a coffee shop in downtown Rochester, how saturated is that market? Who's your customers? Who would be your competitors? We can get you that kind of information. Again, market research, industry reports, industry trends, projections, things like that. My end of the deal in the Business Insight Center is actually to provide people with intellectual property research. So it kind of goes hand in hand. When you are starting a small business, you may have a product that you want to actually protect, whether it be by patent or trademark, or maybe you want to talk about how copyrights might protect your logo. So I'm going to discuss basically the general 3 kinds of intellectual property for things. And tonight we're going to focus on cannabis. So I'm going to talk about patents, which protect generally utilities or how something functions. There's a design patent, which protects the look and the feel of something. And there are plant patents, which protect asexually reproduced plants. I'm going to talk about trademarks, which protect your product or service name, kind of the brand of your company, as well as your logos. And then again, I'll briefly talk on copyrights, because copyrights are kind of, maybe 10% of the intellectual property questions that I get. So the big ones are the patents and the trademarks. So I'm going to share my screen, and we're going to plop over into my slideshow and hope that this works. Okay, so why am I blinking? I hope that stops. If I'm blinking for you, I truly apologize. Is anybody seeing that?
No, it looks good.
Okay, that is so weird. My speaker view is just blinking on the right side. That's going to be annoying. Oh, my word. Okay, sorry, guys. I'm going to try to ignore that. So as I mentioned, who am I? I'm the manager of the Carlson Center for Intellectual Property. I've been that for about 20 years. I hold a US patent and 2 copyrights. So I kind of know the blood, sweat, and tears that is involved in getting intellectual property and protecting what is yours and what you want to protect. Every single year, I'm trained by the experts at the USPTO. So I go down, well, actually the last 2 years because of COVID, they've been remote. But prior to that, I apologize, a garbage truck is coming. Prior to that, I would go down to Alexandria, Virginia for a week of intense training with the experts at the United States Patent and Trademark Office. So we're talking on any new policies, procedures, search strategies, laws, anything like that. We're trained by the experts, whether it be on trademarks or patents. So again, I'll briefly discuss the 3 kinds of patents, which is design, utility, and function. And then I do want to just throw out a little disclaimer that I'm not a biologist, horticulturist, or a lawyer. I'm a librarian and I do love gardening. So cannabis, I just want to touch briefly. Cannabis in New York State, you guys may be well aware that it actually became legal just, I don't even know when, earlier this year. It is still federally illegal. So, okay, it was March 31st, 2021. New York became the 16th state to legalize marijuana for recreational use. The law surrounding marijuana in New York State is extremely lengthy, difficult to understand, and it's changing. If you guys need more information about it, I am going to just say, hey, I don't know. You can check out more at cannabis.ny.gov, and there is all the information that you need, whether it be licensing, production, selling, crossing state lines, all that stuff. Where is it legal? Where is it not? What can I do with it? How much can I have? Okay, that's all going to be covered at cannabis.ny.gov. Okay. And again, I apologize for that garbage truck. Zoom, you gotta love working from home. Patents in general. Patents are property rights that are granted by the government to exclude others from making, using, offering for sale, or selling your invention throughout the US, or importing the invention into the US for a limited time in exchange for public disclosure of the invention. And now you're awarded that in exchange for public disclosure, because the way things get better is that we take something that's old and we say, hey, I wish it could do this, or I really want this to work this way, right? So we build technology on other inventions that have come in the past. So you need full public disclosure of how your invention works, what it's made out of, how big is it, the color, et cetera, et cetera, et cetera. You fully disclose all that information for a 20-year period to be monopolizing on your own invention. That's why that full public disclosure is extremely important. So again, utility patents, they're granted to a new useful improvement of an article of manufacture, process, composition of matter, or a business method. Generally, utility patents are for tangible things. You might think about, pens, computer mouse, trackballs, tangible things. Utility patents actually cover software as well, and that's a whole nother ball of wax. That's a beast. Software actually is a gray area where you can get both software copyright and utility patent. And we can talk about that if somebody has some general questions on software. I just wanted to throw that out there. Generally, utility patents are going to cost you between $7,000 and $20,000 within that 20 years of its life. So it's a lot of money and blood, sweat, and tears that go into utility patents. It varies so large because it depends on the technology that's in your invention. Again, computer programs are extremely difficult to get a patent on, but something like a computer program is going to be the $20,000. It's very technical. You need to understand the science behind it, how things work, algorithms, HTML, all that stuff. That's why something like that is really expensive. As for a ballpoint pen or a clickable pen, you're talking more in the $7,000. Design patents. Those are granted to a new, original, and ornamental design for an article of manufacture. Only the appearance is protected. So the look and the feel of something. And I'll show you a couple examples in just a minute. Design patents run between $3,000 and $6,000, and they have a term of 15 years. Plant patents, they are granted to a new asexually reproduced plant, and they range between $4,000 and $8,000, and they have a term of 20 years as well. So here's an example of a utility patent. Now this one is particularly kind of funny because the story goes that a runner wanted more oxygen while he ran. And so he devised a helmet that had a greenhouse. And why they're showing it with cactus, I don't know. I wouldn't want cactus near my head, but whatever. So a runner wanted more oxygen, so he invented this helmet and put a greenhouse in it. He was awarded actually a US patent. You can see the patent number is 4,605,000. So utility patents again are granted to protect the function of something, how it works. You can think about mouse traps, grill brushes, ballpoint pens, computer mice, etc. Another example of a utility patent is something like a process. Processes are not tangible, but they actually have a function in that the end product is something that you get a utility patent for. So formulas, they are also granted utility patents are also granted for processes like Weight Watchers formula for counting points weight loss system. So there's an actual function, a flow chart, do this, then do this, then do this, and this goes here and that goes there, similar to a computer algorithm. The end result and that whole process to getting there is actually awarded a utility patent. Design patents. Design patents are, again, $3,000 to $6,000, and their term is 15 years. They are granted to new, original, and ornamental designs of something. They only protect the look and the feel and not the function. I think, and if anybody wants to hop in and yell it out, anybody know what this is? What liquid would you find in this bottle? Feel free to unmute and plop in if you want.
Looks like an old Coke bottle.
Hey, excellent. You're still with me. Thank you. Yeah, this is an old Coke bottle. However, you know that Coke still has the ribbed design on the plastic Coke bottles today. They have a design patent on the Coke bottle so that you can actually identify what it is by just looking at it, even though you didn't have the Coca-Cola label on it. This one to the right, you may not be aware of. I think it's Louis Vuitton, the red-soled high-heeled shoe, very nice high-heel shoe. So it's a very classy high-end shoe, and they have the red bottoms, and that actually is a design patent. You can have both a utility and a design patent because one protects function, one protects the look and the feel. But if you wanted to protect everything about a certain thing, how it worked, as well as how it looks, you would apply for both a utility and a design patent. Again, the utility is going to protect the function, design solely the look and the feel. Questions so far? And again, plop in the chat or just unmute yourself. I think is it only Scott?
Looks like there's one other person.
Okay. Feel free to unmute yourself. That's perfectly fine. All right. So plant patents, they range between $4,000 and $8,000, and their term is for 20 years. Again, they're granted to new asexually reproduced plants. What I have on the screen is just an example of a blueberry plant patent. You can read the abstract, and basically it's a new and distinct blueberry. I'm not going to read you the whole thing, but it does say that the attractive large light blueberries exhibit a strong acid flavor at harvest, becoming sweeter a few days following harvest, and possess a very good post-harvest shelf life. With plants, generally you would get a plant patent if there were a purpose, and the purpose might be something like they have a very long shelf life, or you might be familiar with deer-resistant plants, right? So you don't want deer or rabbits eating all of your hosta or your begonias or your geraniums, whatever deer and rabbit eat. If you developed a new plant that was actually a repellent to deer and rabbit, you would patent it because that would be the function that it performs. Another example, let's see. I think I have one more plant patent in there. Going too far. Nope. We'll talk more about plant patents in just a minute. So if color is a distinguishing characteristic of your plant, you would specify the color of the plant as defined by a reference to an established color dictionary. You can read about this, but the thing I want to mention most about it is that you're not going to find color copies on the USPTO's website of plant patents. And we at the Business Insight Center have all the plant patents back numerous years, and were provided color copies of them on archival paper. The reason for this is because red might not look like red on my screen that you see red. So computers display and monitors display colors differently. So if a color is a distinguishing characteristic of your plant and it's very important, you would want to see what the color actually looks like as opposed to what my computer shows you or what your computer shows you. You'll find a black and white image on the USPTO's website or with the subsequent patent on Google Patents or something. You'll just see black and white images of it. You'd want to make sure that if you had a color that was very important to your plant, that you would specify that and then come on down to the library and check out plant patents to make sure that it's actually that portion of the plant is patentable. Goodness. Okay. Questions so far? We're going to dive into the nitty-gritty. How are patents organized? Well, there's millions and millions of patent documents in the world. And to organize those millions of documents, there's what's called the CPC, and that's the Cooperative Patent Classification. You can see on the screen ESPASnet, and that's actually the European Patent Office. They kind of run the CPC or the CPC scheme. It's generally organized into what you see in front. You know, there's human necessities, performing operations, chemistry, textiles and paper, fixed construction, mechanical engineering, physics, electricity, and then miscellaneous. You can find it at the website that's listed here. So if you were to go into that website and you're an inventor and you say you have horses and you're tired of the nails that are currently being used to actually attach the shoe to the bottom of the horse, you've come up with one that's you think is significantly different than something that's already out there. What you would do is go to that website and then just put in a keyword search, horseshoe nail. And what comes up is it plops you into the CPC, Cooperative Patent Classification, and it gives you this really strange number, right? Accessories for shoeing animals. Again, because there's millions and millions of patent documents, you're going to get some funky numbers, but it's very important when you do your patent searching that you pay attention to these numbers, because those are the classifications you would look in to find similar patents to your own to deem if your patent is actually patentable. So we're going to go from human necessities into this here, accessories for shoeing animals. Another way that you can search the CPC scheme is to go back to that screen and think about what it is that you actually are inventing. And again, a nail for a horseshoe is going to be something that's a human necessity. So you would click on A, and then it drops down and it broadens the list of what you see. So you're going to have agriculture, foodstuffs, personal or domestic articles, health and amusement, and it goes on. Right off the bat, you can see under agriculture, we have agriculture, forestry, animal husbandry, which would be shoeing horses, right? Taking care of animals. So you would click on the A01 and it's going to open up even more. And then all of these are going to be under A01. And then here we are at that L, which is of shoeing of animals. I'm going to go on. And then under shoeing of animals, you've got accessories for shoeing animals. And then you click on that and you're finally brought to what's actually inside that CPC. So you guys don't have to know this. It's kind of my world of what I can do for you. I'm happy to do patent searching and I really look forward to working with you guys. Sorry, now comes the recycling. I'm so sorry. Should close my windows. But to search for patents and you have a new invention, you got to make sure that it's actually patentable. And what that means is that it's novel or new, useful, and non-obvious. So we have to search for what's called prior art or inventions that were patented or at least publicly disclosed before your invention to make sure that it's patentable. So I kind of dig around in CPCs every day and I have fun with it. I just wanted to give you a snippet of how it works. So let's talk about cannabis, right? How can you protect cannabis related products? There's a multitude of ways actually you can see here that you can get a utility patent, which we've already discovered protects the function of something. If you came up with a new way of processing a cannabis plant, right? You have this new machine that works a certain way, and you wanted to see if it was patentable, that would definitely be under a utility patent. You could have a design patent, which protects the look and the feel of something. Perhaps you come up with a joint with a signature shape of it. You can get a design patent on the shape of the marijuana itself, or the joint in which you sell it that way. Plant patent, again, they protect asexually reproduced plants if you come up with a new strain of a cannabis plant. Trademarks, they protect the product or service name. So if you come up with a fun trademarked name of a plant, you want to protect it with a federal registration, you would file for that for a trademark. And then copyright, which protects certain creative works like artwork, written materials, photographs. Logos can also be copywritten as well as trademarked. So there's a bunch of intellectual property that actually spans many, many products and services. We're going to focus just for a minute on utility patents for plants. Now, this is a pretty big slide. I'll go over it. So utility patents have been issued for sexually, so that's by a seed, or asexually reproduced man-made plants or elements of plants since the late 1980s. Please don't get that confused with plant patents. Remember that plant patents are for asexually reproduced plants only. A utility patent can protect a sexually produced plant. So elements of the utility plant patent can include proteins, DNA, fruit, plant-based chemicals, the processes used in the manufacture of these plant products. And then you would successfully obtain a utility patent. You have to have it be made by humans, must be novel, have a utility, and be non-obvious. The patent must describe and claim the specific characteristics of the plant for which protection is sought. Sometimes the best way to do this is actually deposit seeds or the tissue of the plant to an international depository authorities for such purposes. Objective of utility patents for plants. So again, we talked about this earlier. If you come up with a disease or insect resistant plant, perhaps there's a drought or salt tolerant plant that you've invented or asexually reproduced. Maybe an herbicide resistant plant, deer resistant, or an improvement of fruit and flower quality. Remember that blueberry had an exceptionally good shelf life? That might have been what he actually sought utility patent for his plant, that it had a good long shelf life. The blueberries wouldn't get moldy within a week. This is an example of a utility patent. It's a system and method for separating and collecting cannabis. It's awarded a utility patent. It's 10 million something, and we can read the abstract of it. I'm just going to try to see if it talks about what they're actually seeking patent protection on. It just says a system and method for separating and collecting cannabis through separate cannabis into plant material, chaff, seeds, and kief, and then collects cannabis byproducts based on size, shape, and weight, etc. So again, this is the utility patent, and we're looking at CPC A 47J 42/16. It's gibberish, or patentees speak for a human necessity for furniture, domestic articles, etc., within the kitchen or apparatus for making beverages, for coffee and spice mills, having grinding discs, and then mechanically driven. Just shows you the breakdown of the utility patent, CPC. This is another one, and it is, sorry guys, I don't know why that's going back. I apologize. Stop. Okay. This is another one for a flavoring process of cannabis. It's systems and methods for matching one or more non-cannabis inputs, such as flavorants, with a cannabis input. And again, we're looking at that CPC code A24B 15/167, or a human necessity, tobacco, cigars, cigarettes, etc., manufacture, preparation of it, of chemical features, etc., 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 down into vaporizable form, liquid compositions for e-cigarettes. See if I can just go one slide. There we go. Design patent. They're kind of fun. This particular one is a design patent for a waffle with a cannabis leaf shape. That would be awesome. In the morning, you'd wake right up, right? So they have a protection on, not the waffle, because that's probably already been patented, or the waffle shape, but they have a patent on the cannabis flower within the waffle. Another design patent is actually for the packaging of the joint pack, not the cigarette pack itself, but the particular way that this one looks. Okay, we're going to get into plant patent CPCs for cannabis. Remember, those are cooperative patent classifications. You could find that again at the worldwide ISPASnet website that you see here. And once you get to that, you would search for cannabis and it automatically brings you into, if you look where I've circled, it's A01H6/00, which is for angiosperms or flowering plants characterized by their botanic taxonomy. And I'm sure you guys could have figured out exactly right where cannabis plants were put in the CPC scheme. Nobody can. That's why you need me. I can certainly search that for you. So we're looking at that CPC. And then you can also see, we kind of looked through that cooperative patent classification scheme, if you will. You get back into human necessity, agriculture. A01H is for new plants, right? And then you search within A01H and you look down to 6/28, and there is your cannabinaceae, which is an example of cannabis. So you can get there. It's rather clunky, but that would be a really good CPC or cooperative patent classification to search if you come up with a new strain of cannabis. You want to make sure that it's not already been patented or one isn't too similar to prohibit you from getting a patent on your own plant. This is just an example. This is a cannabis plant named Honey H-2018. And this one is particularly characterized. You can read through the abstract. It says cannabis plant variety that has a combination of beneficial characteristics that include high potency, sweet aroma, greater tolerance for fungal diseases, and high vigor. So this person came up with a way that it's more tolerant of fungal diseases, it has high vigor and high potency. That's what they're after with their plant patent. Okay, a couple things about patents. You really should conduct a preliminary prior art search, and that's what I do for free. It is confidential, meaning I would need a court order to divulge what you and I talk about. There's nothing that I can share with anybody, nor would I choose to share with anybody about a conversation that you and I have. Anything that I write down, any email, I try to shred and make sure there's really no evidence of what your intellectual property is. So again, it's confidential. It's completely free. Any research that I do for you, any research that Jen, Melissa, or Sarah does for you, it's all free and it's all confidential. The reason why you would want to have a prior art search done is to make sure that you are not infringing upon someone else's patent rights. Again, your invention has to be new, non-obvious, and novel. There has to be a function or an item at the end that is not like something else out there and that it's completely kind of unique, if you will. If you don't find your invention on Google or Amazon or Google Patents, wherever you do your searching, congratulations. That's an awesome first step. Google runs about 6 months behind the patent office. I use a database called Innovation Queue that we subscribe to. You can use it if you come into the library. It's not something you can access outside of the library. So Innovation Queue is spot on with the patent office. It's updated every single Tuesday, which is when the patent office purges new documents and puts them out there. And it makes patent searching kind of fun. It's easy to use, and if you can believe, it's kind of fun. The Patent and Trademark Office website is very, very clunky. It's difficult to maneuver. It's hard to know where you need to search using their website. Patent pending. Patent pending is a term that's reserved for utility patents that have a provisional application. I'm going to back up a little bit. Utility patents are difficult to secure. They generally take 3 to 5 years before your patent application is actually granted a US patent. 3 to 5 years is an extremely long time to an inventor. It can make or break a business. It can make or break a product. You know, it just is a long time. So the patent office says, all right, we're going to devise this way that people can have some sort of protection within that 3 to 5 years while we're still mulling about their paperwork to see if their patent is actually original enough to be granted. Provisional application does 2 things which are extremely important to an inventor. Number 1, it provides you that patent pending status. Why is that important? Well, then you can publicly disclose your invention without the fear of it becoming unpatentable. If I came up with an invention today and I posted about it on Facebook and said, hey, check out my new invention. This is how it works. Isn't this cool? There's nothing that protects me as the inventor of that thing because I've already publicly disclosed it. I hope that makes sense. It's kind of critical. So you want some sort of protection if you're going to talk to potential partners, producers, manufacturers, anybody else within that chain that goes from invention to the store, right? You need to set up your start to finish, if you will. You want to talk to people. You want to talk to Hasbro if you come up with a new toy, or Mattel. You want to talk to Kodak if you've come up with a chemical composition, probably the U of R. But you guys understand what I'm saying. You got to get a provisional application and then that awards you the patent pending status, and then you can publicly disclose your invention. Whew. The second thing it does for you is actually get paperwork on file at the Patent and Trademark Office. We are now a first to file country. What that means is the first person to get paperwork on file at the patent office is awarded the patent. That's a hypothetical picture, but if you and I come up with the same thing and you you mess around for a little while, and then I say, ooh, I got to get my provisional on file, and I do that, and you wait a little bit, and then you file, I'm going to be awarded the patent, hypothetically, because I have paperwork on file at the patent office first. Okay, so provisional patents do not automatically become utility patents. They are good for 1 year. At the end of that year, you have to do the necessary paperwork for a utility patent. I'm just reading through my slide to make sure I covered everything. Confidentiality, yes, confidentiality would be your only form of protection if you don't have a provisional in place. So you'd want to make sure you kept your mouth shut. And if you had to talk about your invention, your new cannabis plant, your new production of cannabis plants, you'd want to have NDAs or confidentiality statements that people sign. Once your patent is granted, you enforce it. The PTO does not police it. You have to make sure that nobody is doing the same thing you are and selling it. You can sue them, but the Patent and Trademark Office basically says, hey, congratulations, here is your patent. Now I want to see you in 3.5, 7.5, and 11 years when your fees are due. Otherwise, have fun. It's up to you to actually police your own invention. Okay. I assume there's no questions. We're still good. All right. Another form of protection for plants is the Plant Variety Protection Act. This actually was administered by the U.S. Department of Agriculture, and it was enacted in 1970. What this does is provide legal intellectual property rights protection to breeders of new varieties of plants which are sexually reproduced or tuber propagated. Remember, plant patents are only good for asexually reproduced plants. Plant Variety Protection Act are good for sexually reproduced or tuber propagated. They're also good for 20 years of the certificate's date of issue or 25 years if it's a tree or a vine. So PVPA certificate owners have the rights. It's very similar to a patent. You exclude others from marketing and selling, import and exporting, or stocking the same variety of your plant. Again, the plants still have to kind of follow the same guidelines, if you will. They have to be new. They have to be distinct and uniform. So any variations are describable and predictable. And it has to be stable, which means the variety, when reproduced, will remain unchanged with regard to its essential and distinctive characteristics. You can find out more right at the link below. This is just a tidbit for you. The first cannabis plant patent was issued in 2016 for Ecuadorian sativa to Stephen Covey. So it's not been too long since marijuana plants are patented. I am going to stop here. Do you guys have any questions? Do you need to get a drink? Anything? Guys still with me? Okay. All right, we're going to move on then. So that puts aside patents and plant protection, if you will. We're going to talk about trademarks. Trademarks are used to protect a product or service name from others like it in commerce. And you see two symbols here. You've got the TM and you have the R with the circle. The TM actually is common law rights. What that means when you see it next to a product name is that they are claiming common law rights to their product name. It is not a federal registration. Again, it is not a federal registration. Once you go through the application process of a trademark and federally register your trademark and it's granted, you would put the R with the circle and remove the TM. Basically, the TM just puts the public on notice that, hey, I'm interested in this name, I'm using it in commerce, and I'm in the application process for a federal registration. Excuse me, these are examples of trademarks. I want to talk briefly about a couple of them. The first one is Nike. Now, if I had cut out the word Nike and you guys just saw that swoosh, I'm going to assume that you would know that it's Nike. If I took out all that and just put just do it, you would automatically assume, okay, hey, that's Nike's logo. So Nike has a combination mark. Basically, they've trademarked the word Nike, they've trademarked that swoosh, and they've trademarked just do it. They've also trademarked them all together and trademarked any variation in which the three of those elements fall together. So you can have a trademark which incorporates a word or words and or a logo or design element. McDonald's, you can see here, they have the golden arches, right? And they have I'm loving it. So they have both of those registered. They can use the golden arches alone or with the words I'm loving it, or use just I'm loving it. The MGM Lion Roar, that one's a little bit different. That's kind of cool because it's a sound mark. That lion roaring at the beginning of any cool movie is actually a sound mark. I'm going to go and see if you guys get this. Dum, dum, dum. I'm sure you're all singing NBC. That is, in fact, a sound mark. And Homer Simpson's "Go" is a sound mark. Harley Davidson's, the low rumbling engine noise used to be a sound mark. They've done away with it. I'm not sure why. But if you heard or hear Harley Davidson, they used to have a sound mark, which is a form of trademark on that engine rumbling noise. Let's talk about Play-Doh. Play-Doh actually is has a scent mark. So if you have children or grandkids or nieces, nephews, and they play with Play-Doh and you smell it, that is a scent mark. I think Verizon stores have a scent mark. When you walk into a Verizon store, there's a particular smell. And if you guys want me to do it later, I can show you where scent marks and things are located. There's another one that is, oh geez, I thought that was muted. I'm so sorry. I'm sorry. Ignore that. Come on. Okay. So Verizon stores, geez, comedy relief. Verizon stores, what's another one? Can't think of one off the top of my head right now, but there's your example, Play-Doh and Verizon stores. The other two marks that are left on the screen are John Deere and UPS. If I removed the UPS symbol on that brown truck, I'm going to guess that you guys would say, duh, that's a UPS truck. Yes, duh, because they actually have a color mark on that shade, that particular brown. If you saw another brown truck rumbling down the street with that exact color and it said ATM, you'd be like, whoa, 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 that's just wrong, right? That's supposed to say UPS, not ATM. Same thing with John Deere. If you saw another tractor coming down the street with that green and it said cow dung, right? You'd wonder, what is that? That's supposed to be John Deere green. All right. So trademarks. Again, a little bit more. Trademarks are divided into 1 to 45 different classes of goods and services, and you can have multiple classes for your trademark. Again, Nike probably has it up and down all of these, though I don't know if they have meats and processed foods. They might. I'm looking at class 29. So under goods, you have the first 34, and these are for things that are like tangible goods. So any product that you can think of that is sold on shelves in stores would fall into one of these 34 classes of goods. Services are things that provide you a service. FTD flower shops, the Oscar Mayer Wienermobile, let's see, I'm trying to think of other service marks, but anything you can think that is, between these classes of 35 to 45, they provide a service as opposed to actually having a tangible product. You can go to this particular master list right here in this link, and actually it's kind of cool. Let's see if I can do it. The PTO makes this one easy, where you just search the ID master list and you would put in, well, let's do bakery, baked goods, right? And it would automatically tell you, okay, it's in class 30, but there's also a service mark, bakery services, right? Namely the manufacturing of bakery products to order or specification of others. But so there's a goods and a service class for bakeries. Okay. For cannabis, generally, cannabis falls into class 31, which is for natural agricultural products. I'm looking for one that might also fall in medical, beauty, and agriculture. If you get into medicinal marijuana, perhaps you would want to look into 044, which is a service mark for medical, beauty, and agricultural products. Okay. Should go. Okay. Trademarks are also why two products with the same name can coexist peacefully on the same shelf right next to each other. So here we have an example of Dove soap and Dove chocolate. Soap is in class 3. Chocolate or sweet foods is in class 30. They're in completely different classes of goods and services. One main concept of trademarks is that they cannot cause confusion in the marketplace. If I go to Trader Joe's or Aldi and I see these two products on the shelf together, I am not going to grab the Dove soap when I'm hungry, right? The common consumer wouldn't mistake these two products, even though they have the same name and their design elements are actually kind of close to one another. If I came up with a soap called Dovelet and I wanted it to be in stores, do you think I would get a trademark for that? I wouldn't have so much luck, right? The trademark office would say, yeah, no, that's way too close to an already established brand of soap. If I had Dovelet chapstick, right? That probably wouldn't have an issue because they're two completely different products. Another one that you consider with trademarks is foreign spellings or direct translations. If you know of Toro Rojo as Red Bull, right, and that's a caffeinated beverage, if I came up with a caffeinated coffee and I wanted to call it Toro Rojo, I would be denied a US trademark because it's a direct translation of Red Bull. These are some of my favorite trademark names of cannabis products. And I think my best favorite is number 8. It's marriage counselor. That one just has me laughing. But there's 15 of other ones that I found were pretty humorous. You can read them. They're kind of fun. I like Dope Dash too. That's a marijuana delivery service. So that would probably be a service mark, right? Dope Dash would have a service mark because they actually deliver it to you. Yeah. So trademarks, we already talked about what class is generally used for it, which is 31, which is natural agricultural products. And class 31 would cover live cannabis plants. You would also consider pharmaceuticals, which would be class 5. Class 34 is smokers articles, trademarks for cannabis products intended for smoking. And then 35 and 39 are actually service marks. So 35 would be for advertising and business, and 39 would be transportation and storage. And I think, yep, that is all that I have. Again, we are confidential, we are free, we help entrepreneurs and small business owners of any size at any stage. It's not a one-stop shop, so we expect kind of an open conversation, as well as, tell us what do I want to say? We don't just help you once and say good luck. We help you as much as you need us and as long as you need us, and we're here for you for your questions. So is there any questions at this time I can answer for you? Because that wraps up my presentation. I'll stop sharing. There. Oh, you're welcome. You're welcome, Scott. Thank you. I'm just checking the chat. Sarah, thank you for putting in our appointment, the email there, and their website. Good, good. Are there any other questions, comments? Okay, I'll remind you guys that in a few days, this the recording with the slides is going to come out in your email. And I really appreciate you listening and sticking with me. And I hope you all have a good night. I'm going to stop recording.